Hi everyone, thank you so much for coming to my talk today on GDPR, CASL, CCPA, CAN-SPAM, oh my, all of the different compliance laws that we need to understand and build out in Pardot to be compliant with our marketing automation. Especially grateful that everybody came because I know that the legalities of marketing isn't always the most exciting part of marketing automation. But it is really important, and I'm going to try and make it exciting for you guys today. So to introduce myself, I'm Chloe Wilde. I'm a CRM and marketing automation strategist at Secante, and also in the chat today, and he'll be jumping in to help with some FAQs later, is the amazing Mike Cruiser. We've both been kind of heavily involved in GDPR transformation projects in the past, so we're both super excited to share that knowledge and experience with you guys today. So essentially today we're just going to be looking at some local and regional laws, do a bit of a deep dive on GDPR, because I know it's still top of everyone's mind even 2 years later, oh god, almost 3 years now. Look at some compliance tools we have in Pardot, and also look at how we can get in compliance and some common questions and FAQs. So to start off, a lot of people ask, do Pardot and Salesforce actually comply with GDPR? And the kind of short answer to that is yes, they give you the tools you need to get in compliance, but the long answer is there are a lot of moving parts with that involve both people, processes, and the tech that we use. But what are those actual laws, and how can we build these tools to work with them? So the main thing I want to say before we get too far is safe harbor, guys. I'm not a lawyer, none of us are. We simply know how to make the tools do what we need them to comply with the laws that we have. So I'm going to give you hopefully some good advice today that's going to help you look into these things, but always consult your legal team. Because let's be honest, what's really important to us is the marketing lens for all of this. We want to know, how can we grow our lists in a compliant way? How do we keep them warm? How do we get the data we need to improve performance? And how can we personalize that data whilst not annoying anyone? And I also want to point out that there's a couple of differences in terminologies that are really key to this conversation. And those are the difference between data privacy laws and email and communication laws. So as marketers, we're always probably thinking, is it okay to be sending this email? But actually, the onus for GDPR is very much on these data privacy laws, and they are different. So I'm going to be talking a little bit about that distinction as we go through this talk. So the one you're probably the most familiar with is the US CAN-SPAM laws. I'm just making assumption here that it's mostly US people in the chat, but let me know, where you're from. With CAN-SPAM laws, it's a little bit different to GDPR because no explicit opt-in is technically required. We do have that legitimate interest piece. You have to offer an opt-out mechanism for 30 days, but you have 10 days to process unsubscribes. So that's a little bit different to GDPR. And I'm not kidding when I say it doesn't require opt-in consent. It really doesn't. However, assuming we're all working in Pardot here, Pardot does have a permission-based marketing policy. So it does require us all to create and manage opt-in subscriber lists. And it is always best to try and get that explicit opt-in on your forms. Pardot also doesn't want you to buy lists, guys. Even though CAN-SPAM says it's okay for some crazy reason, we really shouldn't be uploading purchase lists into Pardot, because if Pardot finds out, they're going to tell you off. And of course, California, as of January 1st, does have its own version of these laws. We've got the Consumer Privacy Act. So companies now have to be really transparent about the types of data they have on you. They're allowed to prevent you from selling that data, and you can request to have your data deleted. So I think the California laws are going to pull potentially the rest of the US a bit more in line with the GDPR that we're familiar with. And then quick kind of around the world in 80 seconds, if you will. So we've got our CASL laws in Canada. So you can see at the top right, we've got the little email. So I'll be making that distinction again between email comms and privacy laws. So in Canada, for example, you're going to mostly need explicit permission unless they're an active customer, and you can mail anybody who's inquired about a product in the last 6 months. And this does also apply to some social DMs and text messages. You've got the data privacy laws, PIPEDA. I can always a mouthful to say that. So you do actually need to have that consent to collect, use or disclose personal information. You need to take precaution when working with third parties, especially if you're buying lists. And you have these 10 information principles, which are available online. Always handy to know if you're marketing in these regions. Brazil, again, they have these 10 legal bases for processing data as well. Sensitive information must be treated differently, and this is another common thread we're going to see with a lot of these. And then looking at like the Australian Act, so this is one that I've noticed a lot of people marketing in Australia recently have a lot of questions about. They do require opt-in. You're not allowed implied consent like you are with the US. New Zealand, a little bit less stringent. So again, they have this list of principles, really common with a lot of these laws, but opt-in is required. So again, no legitimate interest. And then we also have, sorry, just in case he's comment, yes, must include hockey or Tim Hortons, which is incredibly delicious. I miss it. We get to GDPR. So this is the one you're probably really familiar with. Everyone's talking about it. You need a legal basis for processing personal data. Opt-in must be explicit. You cannot pre-check a checkbox on a form, and you cannot grandfather in data you've held previously prior to that 2018 date. So there's a lot to take away here. And then on the email side, I'll be talking about this a little bit, but I'm assuming you kind of guessed by now that the onus is really on the data privacy piece. So the e-privacy directive in Europe is becoming a regulation to sit alongside the GDPR, and it's saying that you're going to need specific consent to send email. You can't have a soft opt-in. You can't disguise your identity. So you need to be very transparent and almost what I would say compassionate with your marketing. But continuing on this thread of GDPR, so I mentioned that the 2018 date. So what actually happened? Because we all expected this, right, guys? We thought it was going to be crazy. But what actually happened was it was all around, data privacy. There were some big fines, but it wasn't as crazy as we all thought it was going to be. The biggest fines so far, we've got Google, BA, and Marriott here. But these fines were all about data privacy. Google, failure to be transparent. The other one's data breaches. There weren't any spam email fines because that's what we were all scared about. But if you actually look at the legislation, how many times does the word email appear in the GDPR? Only once. And it's literally just referring to the use of email as personally identifiable information. Because what GDPR really is about is establishing rights for individuals with regards to their data privacy. So let's talk a little bit about what that means. What data is actually governed by GDPR? So we have personal data, anything related to an identified or identifiable data subject. For example, my favorite color is green. It's not, it's purple. I should change that slide. Secondly, sensitive personal data. So any information on race or ethnicity, political, religious affiliations, any sexual orientation, genetic data. So anything that could be considered personal. A really good example of this that we might use Pardot for is asking for people's meal preferences or t-shirt sizes coming up to an event, because you could infer religious or health information from those choices. So I would always recommend to gather that information in a separate form that doesn't cookie the prospect, because we don't need to know somebody's t-shirt size and connect that to their email address. We just need to know the number of t-shirt sizes that we need. So keeping that data separate and then using the principles of data minimization and deleting anything you don't need afterwards is really important. Next, we've got pseudonymous data. I always find it really hard to say that word. Does anybody else? So this is data that can't be connected back to someone without additional information stored elsewhere. So a great example we have here is, say you're reading Jenna Mulvey's blog, like we all do, literally all the time, it's the best. And Jenna has recorded my IP and links to the pages that I'm viewing. So I've been cookied, but I'm pseudonymous, but because without my name and my email address, Jenna doesn't know it's me. And this is really interesting when we start looking at like cooking prospects in Pardot, because how much information do we actually have, and what, you know, intelligent guesses can we make about who that person is if they're cookied but we don't have their name? It's probably easier to track people than you think if you really looked into it, and therefore that data becomes personally identifiable. So it's really important to know, you know, what kind of data we have, and how can we minimize that data, have as little data as we need to do the job we're setting out to. And then anonymous data. Let's be honest though, we're in marketing. It doesn't exist. Unless you're literally putting a suggestion box in the middle of a forest, it's probably not going to be anonymous for the reasons that I've just described. So, GDPR has some lawful basis for processing data. As email marketers, even though there are 6, there's only going to be 2 that really apply to us, and that's consent if they've explicitly opted in, but also legitimate interest. So the idea that we can process information if there's a valid reason. However, it's a big grey area. It's probably only going to apply for things like if somebody came and spoke to a salesperson at an event booth. That's a really common one I see, that 99% of the time, you know, we really want to try and get that explicit opt-in. And then, you know, what do we actually consider personal data when we're looking at the data we have in Pardot? Firstly, cookies are personal data. We're tracking someone, we're linking that to their email address. So they are absolutely a use of personal data. So kind of a quick summary to comply with GDPR here. So what we should really be doing to make sure we're on track with this: document our internal processes. We should be running data privacy impact assessments for any new technologies we're introducing into our tech stack, and figuring out how they're moving data between the different platforms. Certain types of businesses will need a data privacy officer, depending on the vertical you work in and the region that you're marketing in. Creating privacy policies and making sure that those are linked to in different areas of Pardot, like your email footers, for example, and understand your reporting obligations when a data breach occurs. So, some misconceptions that people have about GDPR. I'll just run through a couple of these. So a lot of people think, you know, we're US-based, so GDPR doesn't apply. If you're holding any data from any prospect that's outside of the US, so if somebody enters a form and they're from the UK, it absolutely applies. You think your data's grandfathered in? It's not. If you obtained it prior to that May 2018 date, GDPR still needs to apply to that data. You need to hire a data protection officer. Again, it's only if you're, you know, headquartered in certain countries, for example. It's really something to have that conversation with your legal team about. I need a double opt-in process. That's a really common one. You only need a double opt-in process for prospects who are situated in Germany, Austria, or Switzerland. Those are the 3 countries where double opt-in is really important. Although I would actually recommend looking into it, because it's a great way of not just building that trust with your prospects, but also data validation to make sure that junk data isn't entering your system. So what is Pardot doing about all this? We've got the Pardot cookie banner, so that visitors can opt into tracking on a per country basis. We have Pardot and the right to be forgotten. After you add people to the recycle stage, if someone's made a right to be forgotten request, remember that Pardot, even though it's not tracking people in the recycle bin, you still need to permanently delete them out of the recycle bin. You also need to delete them out of Salesforce and out of anywhere else in your tech stack, your marketing tech stack, that data is being held outside of customer processing. So really important to remember. And then finally, also business units. I'm excited about this. So there are a couple of articles in the GDPR that cover data minimization and controlling access to data to only those who need it. So a really good way of doing this is using business units, because then you're only giving certain data to people in the business who need to use that data for their job. So breaking things out geographically is a really good way of tackling that. And I also want to give a shout out to Salesforce, who have some great educational resources on this if you do want to do a bit more of a deep dive. So to finish off before we get into some FAQs, I just want to really quickly run through, some common questions and some things you can do in Pardot to really tackle this yourselves and become GDPR heroes. Is an email address personal data? That's one I get a lot. Yes, it is, because it can be tracked to a person. Will keeping limited data limit our exposure? Yes, data minimization is really important in GDPR. It's great. So, don't keep data that you no longer need, especially things connected to, say, time-bound events or campaigns. If you don't need the data anymore, get rid of it. If a prospect attends an event, is this legitimate interest? Grey area, technically yes, more so in the US than in the EU, but yes, if somebody's actually come up to your stand, they've spoken to a salesperson, they've given a business card, it's tricky, isn't it? Because they haven't ticked a box to say they explicitly opt in. But I think, again, that's a conversation to have with your legal team. It is a grey area, but that's a really interesting one, and technically, yes, it is legitimate interest. Is opting out the same as the right to be forgotten? No, because if somebody is opting out, they're saying, it's okay that you have my data, I just don't want to receive marketing information. If somebody makes a right to be forgotten request, they're saying you need to delete their data completely out of your system. And on that note, does the right to be forgotten change when a prospect becomes a customer? Technically, yes, because if somebody is a customer, you can have as much information as you need on that customer to be able to do, to fulfill the contract that you've created between you both. So you can have all the information you need for billing purposes, just not marketing purposes. And when do you need a double opt-in strategy? If your prospect's in Germany, Switzerland, or Austria, then you definitely need one. But it is worth looking into outside of that, just for that data validation piece and building that relationship with your prospects, knowing that they want to hear from you. So I think some action items I would love you all to take away from this are what I like to call design, document, and decide. So design an affirmative opt-in process. Update any custom fields, automation rules, update all of your conversion points. You've got that explicit opt-in checkbox. Make sure that Pardot is doing what you need it to be compliant with your local laws. Document all of your marketing and lead gen policies. This is really important. Nobody wants to get audited by the ICO, so having that documentation is really useful. Review your privacy policy. Make sure you have it on your email footers and anywhere that prospects might be interacting with you, like your landing pages. Make sure that you have a privacy manager or even just a champion for GDPR and compliance within your business or in your team. And decide if you're going to regionalize this or adopt one policy across the board, because of course you can change Pardot automations to take different actions depending on the country that a prospect is in. For example, using things like dependent fields on Pardot forms to show different types of opt-in options depending on the country that they choose, which is a really cool little tip. So areas that I'd be looking at reviewing in Pardot after this are our forms, making sure that they state what information will be collected and how it will be used. Checking our emails and making sure they link to the privacy notice, they've got our address in the email footer. Checking email preferences. Have we indicated that the subscription options on our preferences page are used for marketing purposes? Do we have any sensitive custom fields? Is that data current and accurate? Can we remove anything that we're no longer using? And access, that's the big one. So are we using Salesforce User Sync? Are all of our Pardot users current and necessary? And are any places and systems that process personally identifiable information well documented and within easy reach for all of our teams? And then, of course, there's a few things to look at in Salesforce as well. So we can look at things like data deletion, consent management, controlling visibility using things like profiles and company-wide sharing settings, setting up custom objects in Pardot. So there's lots here we can do. But of course, you're probably wondering, who am I going to market to after I've removed all of this data that no longer consents? It's okay, guys. There are plenty of ways we can grow lists in a compliant way. We can ask for consent on points of lead conversion. We can automate adding and removing clients and active prospects to mailable lists where there's legitimate interest, so we know that all of that data is current and accurate. We can make sure that we've called out everything we're doing in our privacy notice. And of course, we can make sure that our email preference page is up to date, and that we're making sure that our email footer for sales and service teams are also asking people to opt in. So we're really, taking this beyond marketing. We're taking it to anybody who's customer facing and working with our clients. So a lot to take in there. I'm sure you guys have plenty of questions. We might have answers. We're not lawyers, safe harbor. So yeah, I don't know if you want to jump back in, Cruiser, and we'll see if anybody has any questions for us. I did see a couple of questions. Is the UK part of the EU, and is GDPR still in effect? Yes, as of right now, to be determined. Hey, Cruiser.
Hey, Chloe. We had a couple of good questions come in on the Q&A. I answered them by typing, but they should be covered. So the first one, does GDPR seem to be the global standard, or are there country-based regulations that exceed the GDPR requirements?
Yeah, that's a great question. It's really interesting because GDPR does seem to be becoming more of a global standard, because we have these California laws that are, a little bit more towards GDPR than the CAN-SPAM laws. And of course, we have the Pardot permission-based marketing policy, which does go a step further than CAN-SPAM, even though Pardot is, of course, a US company, because it's requiring that we don't use purchase lists and that we do get opt-in from our customers. So it's safe harbor, yeah. So that is interesting. I don't know if there's anything you can add there, Cruiser, but I really do feel like it's a safer bet to be managing our compliance kind of under this GDPR umbrella right now.
Right. I would probably adopt GDPR globally, and then knowing that there's local extras. You mentioned it briefly, Switzerland, Austria, Germany. I think those are the countries you mentioned. We need a double opt-in. That's a actual country-specific extra requirement on the e-privacy policy requirements. So there are, even within the European Union, there are still additional pieces that are for specific countries. Non-GDPR countries, China, Russia, have laws that state that data processing must occur within their own country, which is actually the same thing GDPR has. GDPR has better different ways of allowing processing outside of those of the parent countries. Japan has a requirement around when somebody clicks unsubscribe, they must be unsubscribed right now, which is different language than most other languages would have, which allow a reasonable time period, whether that's 7 days, 30 days. It's not hard to tell. CASL has, not CASL, CCPA has some language with consumers that is more than what GDPR has. Dealing with information on children, there's a little bit stronger language in California than GDPR. So there are very much regional differences that we have to be aware of, and we'll need to work with our legal teams to figure out how we need to work with that. Another question. Do we have a cheat sheet that goes over all the fun compliance rules? Like, there was one of the slides, about slide 6 or slide 7.
Yeah, if we can still see my screen, I can just jump back.
Yeah, so, I see we've got answers.
There we go. Bit of a cheat sheet.
Yeah, and this is not inclusive. This is just, a crib sheet. It is not all inclusive.
I feel like I should write a blog on this, Cruiser. I should do a blog just covering all of the different compliance laws, because this is a question that I get asked a lot. I think a Q&A also came in from Becky asking if we have custom fields for consent that you track in Pardot on Salesforce. Yeah, this is something that I really like doing, because the Pardot opted out field is binary. You just have this like true false. So something that I really love doing is having a custom field instead. That has something like opted in, opted out, and then unconfirmed. Because using that unconfirmed status, we can use an automation rule to set somebody who has opted in as unconfirmed and then send them that double opt-in email. So, for example, you can create, a dependency in your form that says, if somebody is from Switzerland, Austria, or Germany, we're going to set their status to unconfirmed, send them an email, and then there'll be a custom redirect in the email that if they click it to confirm their email address, it's going to change their opt-in status to confirmed. So there's definitely ways that you can use custom fields to really, customize this opt-in status and make that user journey for your prospects a lot better.
Also, I point out in the roadmap keynote yesterday, there's a individual object in Salesforce, and Pardot is being set up as part of that roadmap to work with that individual object. That individual object is Salesforce's technology to try to support the right to be forgotten and still know that, like, we're not supposed to remember this individual. That they told us to forget about him, but how do we know that we're supposed to forget about him if we have deleted the record that we're supposed to forget about him? So there's this individual object in Salesforce that exists to deal with that, and that was on part of the Pardot roadmap. Chloe, I do have to jump to my next session. Typical Zoom, right? But there's a couple more Q&A questions. I believe you got these, right?
Yeah, I'm good. You can jump.
All right, thank you very much.
Great. Thanks, Cruiser. Awesome. So a couple of the questions I'm seeing there. So you're asking, opt-in is thrown around a lot, but is there a firm declaration of what that looks like? Does it need to be applied through registration, or does it need to be a physical act? Really good question. It's a tricky one, isn't it? Because somebody can click a link that says unsubscribe, for example, in an email, and that's a very physical act that says, I don't want to hear from you. But also, if somebody fills out a form and they don't hit that checkbox, is that also saying that they want to opt out? Again, it's a gray area. Personally, I would say yes. I would be setting up an automation that says if somebody fills out a form and they do not click the box to opt in, then I'm going to opt them out. However, I'd also have almost like an undo rule that says if they come back and fill out a form at a later date and then they want to opt in, or they've opted in previously and then they filled out a second form and they didn't opt in, we want to reverse that status. So I would be considering their intent as well as their actual physical actions. Another question there is my understanding that GDPR says a person has to opt in, but United States people can be forced to opt out. So can you give a little bit more detail on what you mean by that question? So person has to opt in, but they can be forced to opt out. Do you mean because you can have legitimate interest in the US? I think that's what that means. So if you've explicitly opted in via GDPR, but in the US, then prospects can be opted in via legitimate interest because you think that they want to hear from you. You do, because by sending them email, you still have their data on file. So even if you've got it via legitimate interest, you're still holding their data. So there's still definitely that onus there that if they have opted out, so they've hit an unsubscribe button and you have their data, even though they didn't give you the explicit consent to begin with, you do still need to unsubscribe them, or if they make a right to be forgotten request, we do still need to delete their data. Okay, looks like we're at 19 past. I think I have time for one more question. I'm loving all the questions coming in from Becky Daniel. You're so on it. I'm totally seeing you as like the GDPR champion where you work right now. So for giveaway contests, do you say that those contents are only available for those who have consented to receive marketing emails, or do you have that as a separate checkbox for opting into marketing emails? That's such a good question. I've never been asked that before. I would say that it's always safer to have an additional checkbox. A lot of people do, they'll enter giveaways. A lot of people enter giveaways with like fake data. So that's a really good use case for making sure you've got data validations in place as well, and making sure that, if you're not using, say, a double opt-in, like a confirmation email, you're at the very least checking that data as it comes into the system. But I think that's a great idea, especially if they need to give their address, is having an additional checkbox to say, hey, we are actually going to follow up with marketing emails, so please let us know if you don't want to receive these. So unfortunately, it does look like we've gone a little bit over time, but thank you so much for all of your time today, guys. You've all been super engaged. It's been really nice. I'm going to take that advice as well. I am going to write a more detailed blog about this because I think that would be awesome. Feel free to, follow me on Twitter, get in touch if you have any other questions. And yeah, thanks so much. I've had such a great time. Cheers, everyone.